At our law firm, we represent cruise ship passengers that have suffered injuries during the course of their cruise. Now, cruises can be a lot of fun. They're a great way to see, particularly Southeast Alaska, where many of the cities are only accessible by boat. I've been on numerous cruises throughout the Caribbean, Alaska, and Hawaii. My legal career began in Florida representing cruise ships and their insurance companies. And then when we moved to Seattle, I continued in that, defending cruise lines in passenger injury litigation. A trip and fall or a slip and fall accident aboard a cruise ship is governed by general maritime law. An injured passenger has a general maritime law negligence cause of action against the cruise line for injuries that happen on the cruise or on a cruise ship excursion. The cruise lines do just about everything they can to limit their liability for the inevitable accidents that happen during cruises. And the cruise lines put a lot of fine print into your cruise ticket. Many people don't know this, but your cruise ticket is actually an admiralty contract interpreted under the maritime laws. And the courts do enforce the limitations that are contained within your cruise ticket. The cruise ticket dictates where litigation may take place against the cruise line. All cruise ship litigation takes place in the federal courts of the Southern District of Florida in Miami, and some of it takes place here in Seattle in the Western District of Washington. The cruise ticket requires suit to be brought in federal court. The cruise ticket also shortens the time period in which you may bring a lawsuit against the cruise line for an injury that happened during a cruise. So not only does it reduce the amount of places where you can actually sue the cruise line, it also reduces the time you have to bring a claim. The typical cruise ship ticket requires that you file a written notice of claim within 6 months' time, or else your claim is lost forever. This written notice of claim is typically a letter setting forth what happened and the passenger's intent to hold the cruise line responsible. The cruise ticket also contains a 1-year limitation period within which suit must be brought. If the lawsuit is filed 366 days after the accident, the claim may be barred forever. For cruises that do not touch United States ports, there are additional limitations that may apply. So it is important that you seek counsel with an experienced maritime lawyer after suffering an injury aboard a cruise ship. Generally, the passenger has a general maritime law negligence action for cruise line injuries. There are occasions where strict liability may apply. Since the cruise line is a common carrier, the courts have held that strict liability applies to any injuries that are suffered at the hands of an intentional assault perpetrated by a crew member, whether it actually happens aboard the vessel or when ashore. The Cruise Vessel Security and Safety Act was passed into law in 2010 by President Obama in response to some of the frequent incidents that are occurring aboard these cruise ships out at sea in international waters. Under this statute, guide rails need to be of a certain height. Your stateroom must have a peephole that allows the passenger to peep out and see who's at their door in the middle of the night. Additionally, there are reporting requirements for criminal activity that take place on these cruises.